Good afternoon, everyone. My name is David Harris with the Charles Hamilton Houston Institute for Race and Justice. We've started a whole new regime here this year of getting started on time, and it's great to see all of you here, and it's a tribute to you that we're going to do this, in addition to the fact that we are on short time. So on behalf of Dean Manning, I want to welcome you to the law school. Also on behalf of Professor Brown-Nagin, I want to welcome you to today's event. She's unable to be with us today, but she did describe our guest today as one of the foremost comparative legal scholars working in the field of race and law today. So we're very fortunate to have her with us. I'm going to do a little bit of calendaring before we proceed. On October 25th, we will host a forum on forensic science co-sponsored by ProPublica and the New York Times Magazine. On November 7th, Johns Hopkins professor Martha Jones will talk on her new book, Birthright Citizens. And on November 16th and 17th, we'll host a major conference on race, racism, and mental health, co-sponsored by the Mental Health Legal Advisors Committee. And I encourage you to kind of monitor our website. There are a couple of other things that we have in the works that we hope you'll be able to join us for. So we're really excited to have Professor Hernandez with us today, not only because she's a scholar of the first rank, but also because the content of her work is so critical, compelling, and timely. I'll not dwell on her biography, which includes degrees from Brown and Yale and all that good stuff, or her list of publications, which is quite lengthy in leading scholarly journals and in multiple languages. But I want to emphasize that her work tackles topics that others avoid. Can it be 10 years ago that we heard declarations with the election of President Obama that we had reached a colorblind society? At the time, I noted colorblindness is an affliction, not a cure. It's a matter of not seeing something that's really there in front of us. Just last week, I attended a meeting in which public officials referred to non-white as a category and spoke of majority-minority, Boston as a majority-minority city. We clearly have much to learn and think about. Indeed, as Harvard is being sued over its admission policy, our ability to think clearly about questions of race is too often blurred by misconceptions born of ideology. Today's talk promises to provoke and enlighten as Professor Hernandez tackles mixed race stories of discrimination. Before we begin, don't creep out, Kelly. As always, I give thanks and praise to my colleague, Kelly Garvin. She keeps these things together. Last week, I coined the phrase, she's like the ever-ready bunny who keeps these things coming at us, and she has done so today, and I want us to give her a little round of applause. Thank you, Kelly. And now, please join me in welcoming Professor Tanya Katerí Hernandez, whose book is available for sale by the Coop for $40 at the back of the room. Professor Hernandez.
Thank you very much. It is a pleasure to be here. Just out of curiosity, so I know who I'm talking to, how many of you here are not law-related people? Oh, good. Okay. Because I always like to spread the word. So it's helpful for me to know that. All right. So let me just jump right into it because I know that David's going to yank the hook and take me off the stage like an Apollo singer. So within the last few years, the growth of a mixed-race population in the United States that identifies itself as multiracial, biracial, etc., has commanded public attention. My early work analyzing the proposal for a multiracial census category for this growing population noted that there was a public perception that multiracial racial experiences were distinctive from those of single-race identified persons. Moreover, the public fascination with multiracial identity promoted the belief that racial mixture would in of itself destroy racism. For instance, leaders for the recognition of a multiracial census category frequently posited that multiracial persons were a unifying force, I'm quoting them, on the theory that these individuals as a group may be the embodiment of America's best chance to clean up race relations. Indeed, the equating of racial mixture with racial harmony is often quite explicit. The multiracial discourse narrative is thus that mixing away racism will absolve the nation from having to address entrenched racial disparities in socioeconomic opportunity. The book I want to talk to you about today, Multiracials and Civil Rights, seeks to identify the danger to equality from this public presumption that multiracial racial experiences are disconnected from the continuing power of white privilege. The book seeks to make a very particular intervention in the literature that focuses upon the increase in multiracial identified persons who file discrimination claims within the U.S. legal system. The presence of fluid, mixed-race racial identities within allegations of discrimination have been described by some legal scholars as an emerging issue necessitating reform of what they view as a very dated civil rights legal structure that was presumably built upon a foundation of very strict whiteness versus blackness model. Building upon the social movement for recognition of multiracial identity generally, these scholars have concluded that courts misunderstand the nature of discrimination against mixed-race persons when these judges do not specifically acknowledge the distinctiveness of multiracial identity. I use the term multiracial identity scholars. I know it's a mouthful, but let me see why I use it. I use this to refer to the authors whose scholarship promotes the recognition of a distinct viewpoint regarding multiracial identity for civil rights law. And so I'm not engaged in the analysis of identity formation, et cetera. My book disputes the premise that civil rights law needs to be completely reformed. The book identifies and discusses multiracial discrimination legal cases to illuminate the disjuncture between the existing theoretical critique and what I view as the actual adequacy of the judicial administration of the claims in the varied civil rights context of employment, housing, public accommodations, and even the criminal justice system. The book's close examination of the civil rights cases shows that the overwhelming number present a complainant whose description of the alleged discrimination includes pointed and derogatory commentary about non-whiteness and blackness often. The overarching commonality then in the cases is the exceptionalism of non-whiteness rather than multiraciality as problematic. Although the complainants may personally identify as multiracial, they present allegations of public discrimination rooted in a very specific non-whiteness bias that is not novel, nor is it particular to mixed-race persons. So the objective of the book is to elucidate the distinction between the presumed exceptional space that multiracial persons are rhetorically imagined to occupy in this public discourse and the white versus non-white racial realities that they actually experience when they are discriminated against. And so I'm working in the world of how does discrimination operate. Let me give you an example of at least one paradigmatic multiracial discrimination case, right, that forms the basis of my analysis. I'll take one from the employment discrimination context because that's one that's immediately accessible to us all. We all want to work and we all want to be treated fairly in the workplace. But I do want to state at the outset that the patterns that I'm going to describe in these workplace discrimination cases follow through in housing, in public accommodations, in the criminal justice system, et cetera. Okay. So let me tell you one person's story. Jill Mitchell is a light-skinned biracial woman with a black father and a white mother. I'm using her terms to describe her. She says that based upon her appearance, that many people presume that she's mixed Hispanic and of European ancestry. So she starts working for a retail establishment, Champs Sports, you may be familiar with it, as a full-time management trainee. She works there for a whole year without any incident, and it actually receives very positive performance evaluations and praise about her work. But she feels that her entire work experience changes once her store manager discovers that her racial background includes some African ancestry. Despite the fact that she did not disclose her race on her job application, and she declined to identify her racial background when asked during the job interview. Some of you in the room may be familiar with the "so what are you?" question. She doesn't engage in that conversation. The manager, you may be wondering, well, has the manager figured it out? Because she says it's not apparent in her facial presentation. The manager deduces, or presumes to deduce, her racial ancestry, that includes African ancestry, by the repeated visits to the store of her darker skinned relatives and her nucleus of dark skinned friends. So some might say she was outed by her family. When they showed up, it's like, who are these dark skinned people? Oh, they're my family. Oh, that was where the boss finds out, that it's not just any mixture, it's a mixture that includes African ancestry. Jill says that her manager's attitude towards her changed dramatically. Those are her words. As he fixated on her African ancestry. He starts to make very negative remarks to her about black people, and on one occasion even says to her, why is it that you only date black men? As if this were problematic about who she dates. At one point, she starts to get nervous when she overhears the manager say, we need to get her out of here. So the store manager's racialized treatment of her continues until she's eventually demoted, and her former position as a management trainee is filled with a white employee who comes not from the ranks of the established management trainee program like herself, but instead from the part-time hires. As a result, she attributes her demotion to race discrimination and files an employment discrimination claim. Now, her chances for winning her lawsuit were quite low, and not because of the relative merits of her claim or because she's mixed race, but because it's been empirically documented that very few complaints of racial discrimination nowadays ever yield a success for claimants in the United States. The vast majority of racial discrimination claims are dismissed by courts without the opportunity for a trial. Commentators attribute the low success rate of these growing hostility with which courts greet allegations of discrimination as part of the belief that the passage of the civil rights laws alone have wrought a post-racial society in which instances of discrimination are rare. It's always about something else. It's that you have a bad personality fit, you don't meet with the cultural expectations of the job, but it's not about race. Despite the overarching challenge of persuading a court that an instance of racial discrimination has actually occurred, Jill has an initial motion for court-appointed counsel that gets greeted. Meaning, she's asking the court to provide her with a lawyer at government cost. Now, those of you who are familiar with some TV shows or criminal process, that may not sound so unusual, right? You get a court-appointed lawyer. But we only guarantee that in the criminal context because your liberty is at stake. In a death penalty place, your life is at stake. In civil cases, that is non-criminal cases, we have no such guarantee, no such right. It's when I tell my colleagues that this woman got a court-appointed counsel, they're like, what? In a civil case, and then double what? When they hear it's an employment discrimination case. This never happens. So she is successful in having this happen. Now, why is this so significant? It levels the playing field for a claimant, right? Where the employer is a repeat player in the process, right? So that is to say, employers are used to getting, having to be in court, and so they have one on retainer, and they've got the same lawyer who knows them, et cetera, and they have the resources, right, to adequately defend their claims. When a claimant such as Jill gets the same sort of power to have a professional research her claims, articulate it, et cetera, she now has a better way to amplify her story. And sure enough, after she gets this lawyer, a confidential settlement agreement was reached. Right? So she is compensated for the harm that she experienced in the workplace. Okay, so why then do the multiracial identity scholars who look at this very same case that I've described to you, and they count it as a loss? They say that it was a problematic judicial administration of her claim. Here's the why that they describe in their literature. Throughout the court opinion, the court refers to Mitchell as black. Right? The judge first describes what her own self-identity is, but then in doing the analysis as to whether or not she has a viable claim of discrimination, et cetera, he focuses on her and refers to her by a much more reduced identity as black. So for these multiracial identity scholars, the court's singular focus on blackness means that despite the favorable outcome, that the court has failed to recognize the possibility that her mistreatment was the product of anti-multiracial bias, right? That the multiracial bias has been erased from the court's analysis. From their perspective, the court's oversimplified reference to Mitchell as black is analytically problematic. Right? And again, despite the fact that the court also emphatically states that Mitchell has a discrimination claim that warrants, right, the dedication of public resources in a court-appointed counsel. More importantly, the court's reference to Mitchell as black parallels the singular salience of blackness that her own narrative raises. Nor can the black focus of her own factual allegations sort of be dismissed as, well, maybe her lawyer was the one who thought this is the better way to tell the story because judges are more familiar with a black versus white binary dynamic, etc. The problem here is that this is her story, in her words. She doesn't have a lawyer yet. Everything I've described to you is about how she represented herself in her handwritten complaint and how she defended herself before the magistrate judge in her petition for a court-appointed lawyer. In fact, close to 40% of all the workplace discrimination cases regarding multiracials that I assessed were with complainants who represented themselves, used their own words to describe how they felt targeted and harmed. So this Mitchell case, then, I believe is inappropriately described by multiracial identity scholars as illustrating a judicial confusion about the nature of multiracial discrimination and the inadequacy of the existing anti-discrimination legal framework. Instead, the Mitchell case demonstrates the coherence of judicially focusing on what they term monoraciality, means single race identity, when the claimant herself articulates a factual pattern enmeshed in this single race monoracial bias rather than anti-multiracial bias. And that is the pattern in all the multiracial discrimination cases that I was able to find in all the various different contexts and with diverse ethnicities and racial ancestries. So that is to say, this is not just a black-white story, so to speak. This judicial receptivity to multiracial claims concerned with non-white bias also extends to allegations of non-black anti-non-white bias. Well, that one is a mouthful. But maybe it's better that I just tell you a story. It's always easier, right? So let me tell you about a woman named Henrietta Donner Hendrick. She describes herself as a multiracial Filipina. And she, too, brings a discrimination case. And also, like Jill, manages to survive the move that employers often make of, motion to dismiss. This case has no merit, and we shouldn't even go to a trial. It should just be dismissed outright. She manages to survive that by saying and showing the judge that there's something more here than what the employer believes. It warrants an inquiry. So let me tell you what her deal was. She was an instructor. She taught computer graphics at New York Institute of Technology, but not in New York, at its campus abroad in Amman, Jordan. She had a 3-year contract. And during her tenure, she reported that a superior that she had observed, a Caucasian woman who was the coordinator of the computer graphics department, had scolded and explicitly insulted another professor for his devotion to Islam. So here Henrietta is the snitch in the room. Okay, right? So as a result, right, of her disclosure, right, about her employer or her supervisor, that woman is replaced and another individual comes in as the coordinator of the computer graphics department. But here's the key thing for you to keep in mind. The woman who was disciplined is allowed to retain her job. Right? So she continues on as an instructor at the Amman campus. In contrast, Donner Hendrick, right, Henrietta, was terminated midway through her 3-year contract after making what the employer felt was a religiously provocative comment to her class. Let me tell you what it was. You all can assess for yourselves how provocative it was. Okay? she, in hoping to promote creative thinking among her students, she tasks them with creating a shoe-shaped pink mosque that would be for women only. That's all she said. That was the assignment, and that was viewed as religiously provocative. Now, I don't think we need to assess whether it was or not. Let's presume, right, that it is religiously provocative, as the employer did. The court still found that an inference of race discrimination could be drawn because when her white female supervisor had a interaction that was viewed as problematic as far as an anti-Islam bias that she was demonstrating, she was allowed to stay on faculty, and despite her demonstration of religious intolerance. In contrast, Donna Hendrick is terminated, right, for what is thought of her as her implicit critique of Islam in the creation of the assignment to her class. So here, the court's analysis of the racial discrimination as bounded by a white versus non-white reality again responds to Donna Hendrick's own factual allegations of a white versus non-white reality and treatment in the workplace. In fact, after the court refuses to dismiss the case and thus validates the viability of the claim, that's worth doing a factual inquiry into, the parties successfully enter into a confidential settlement agreement, right? That's code for she got some money. She doesn't have to go back to that job, because few employees want to go back to the job, right? Because it's a hostile place to be, especially after you filed a discrimination claim. Right? So this case then illustrates the success of one of the very few non-black related multiracial claims in a universe of cases very deeply embedded in patterns of anti-black bias. Yet notwithstanding the singularity of this non-black identified multiracial discrimination case, the multiracial identity scholars are primarily concerned with what they view as a judicial overemphasis on blackness. At the same time, though, their critiques underemphasize the significance of white privilege. Now, what is it then that drives them, right? If what I'm describing to you are cases where people are winning in the terms in which people win in employment discrimination cases these days, or getting a settlement agreement, then what do they find so problematic? For the multiracial identity scholars, the primary locus of multiracial discrimination is in any societal resistance to the assertion of a multiracial identity. I sort of call this, lump it as personal identity equality. This is evident in the literature's concerns about courts that erase a multiracial identity and refer to multiracial claimants as simply black, in their apprehension that the law currently forces employees into an unnatural and uncomfortable identity. It also constitutes the insistence from some scholars that a specific multiracial category be officially added to the text of anti-discrimination law. Now, this latter, right, this concern for a specific inclusion of a multiracial category within the text of anti-discrimination law is somewhat curious when we consider that none of our statutes, Title VII, includes a list of racial categories. We don't have a requirement that you be of any particular race. Anyone can file a claim if what they are asserting is that they were treated unfairly, not on the basis of merit, not on the basis of their credentials or lack thereof, but because of race. That's the language of the Title VII, right? That if something happened because of race, not your particular race, just that there was a racialization process in a public sphere in which non-merit-based claims, right, non-merit-based treatment is forbidden. Okay. Now, the multiracial identity scholar focused then on personal identity as a central issue of equality, I think, is better understood as part of the larger multiracial social movement preoccupation with identity. Indeed, in the multiracial community lobby for a multiracial category on the census and other government data collection forms, the individual's right to choose an identity was what was situated as a civil rights claim, right, as opposed to the details I'm sharing with you, right, what happens when people get discriminated against. Yet this individual identity focus of the multiracial social movement, when transplanted into the legal context, in my view, obstructs the ability to understand the needs of multiracial victims of discrimination. For multiracial identity scholars, the perception of multiraciality as challenging traditional civil rights, black-white, approaches to discrimination is so transfixed upon the presumed exceptionality of mixed race status that it loses sight of the true sources of discrimination in the existing cases. This disserves the needs of multiracial persons experiencing discrimination. What my research reveals is the enduring operation of white privilege and the continued societal problem with non-whiteness in any form. In case you're thinking ahead, it even shows up in these cases that look like, oh, there are no white people in the workplace. It's a black identified workplace with darker skinned black people discriminating against lighter skinned people who happen to be mixed race. You want to talk about that in the Q&A? I'll be happy to tell you more of those stories. But same parallel, focus on concerns with whiteness is what is driving them. But this insight is lost in the midst of the multiracial identity scholars' singular focus on promoting mixed race identity. Multiracial victims of discrimination will be better served by legal analyses that seek to elucidate the continued operation of racial hierarchy when whites mistreat them because of their non-white status, and when non-whites mistreat them out of fear that light-skinned multiracial individuals will exercise white privilege over them. But this can only be done by shifting away from a focus on personal identity recognition to a focus on socio-political, group-based racial realities. Right? And that's what I focus on in the book. Now, some might suggest that multiracial promoted personal identity equality, sort of exaltation of personal identity as a civil rights issue, is not necessarily incompatible with the traditional civil rights group-based material inequality approach to civil rights. Like, Professor Hernandez, what's the problem? There's enough room under the tent. Why not take this under consideration too? The problem here is this. Personal identity equality in law is not innocuous when it interferes with the ability to identify and address the material inequality that individuals are exposed to apart from their personal identity. Right, a significant deficit of the personal identity view of civil rights is its abstraction away from articulating institutional forms of racism and the pervasiveness of white privilege. When the personal identity focus of the multiracial social movement is transplanted into the legal context, it obstructs the ability to understand the needs of multiracial victims of discrimination. Now, more problematically as well is that this rhetoric, right, of personal identity equality has come to be used in ways that undermine the enforcement of anti-discrimination law. I'm going to give you an example. When Supreme Court Justice Roberts directly posed questions regarding the implication of mixed-race candidates for affirmative action programs when the UT system was under consideration, first in 2013, Fisher 1. In the oral arguments in Fisher 1, Justice Roberts questions how compelling the university pursuit of a diverse student body could be if a candidate who was, here I'm quoting him, 1/4 Hispanic or 1/8 Hispanic is allowed to identify on the admissions application as just Hispanic without the university interrogating and verifying the veracity of the racial identification. For Justice Roberts, mixed race applicants are a cause for generating skepticism about the integrity and the ability of affirmative action to truly achieve racial diversity. And nor is the skepticism limited to Justice Roberts. When the Supreme Court re-examined the UT policy in Fisher 2, two other Supreme Court justices joined Roberts in raising concerns about the viability of affirmative action in light of multiracial identified applicants. In Fisher 2, Justices Alito, Roberts, and Thomas join in a dissenting opinion that opines that the affirmative action program was faulty because, here I'm quoting, as racial and ethnic prejudice recedes, more and more students will have parents or grandparents who fall into more than one of UT's 5 enumerated racial groups on the application. This presumption that the increase in multiracial identified applicants undermines both the implementation and justification for affirmative action did not originate with the justices. As with the Grutter and Gratz litigation in Michigan a decade earlier, the challenge to UT's affirmative action program was replete with opposition papers referencing the presumed significance of a mixed race applicant pool. This has been a coming. What each of the foregoing examples demonstrate is the influence that multiracial identity discourse has had on justifying challenges to policies of racial inclusion, even in cases where the Supreme Court has ultimately endorsed, temporarily, who knows, right, the constitutionality of affirmative action, while at the same time imposing constraints on its use. Especially alarming, then, is the Supreme Court's reference, once again, to mixed-race persons in its decision authorizing outright state bans on affirmative action. So I'm almost at the end before Q&A. In Schuett versus Coalition to Defend Affirmative Action, the court held that a public ballot-initiated amendment to the Michigan State Constitution that bans the use of affirmative action at public universities, that this is not state action that inflicts an injury on racial minorities in violation of the Equal Protection Clause. In assessing the ballot initiative in Schuett and whether it was intended to harm racial minorities, Justice Kennedy asserts in the court opinion, here I'm quoting again, in a society in which those racial lines are becoming more blurred, the attempt to define race-based categories also raises serious questions of its own. In short, over 2 decades of multiracial discourse situating mixed-race persons as racially unique and emblematic of racial progress has bolstered the opposition to policies of racial inclusion and provided such opponents additional fodder for their argumentation. Rhetoric has consequences. Indeed, the Supreme Court affirmative action litigation, references to mixed-race persons, has paralleled the public discourse notion that the growth of multiracial identified persons signals the decline of racism. Only a direct challenge to the personal identity perspective, like the one comprised in the book, has the potential, in my view, to more effectively pursue racial equality, because impurity and hybridity in of themselves are no guaranteed challenge to the racial order of racial hierarchy and privilege. Okay, so before I open it up to questions, just a few more words about sort of the methodology of the book, what have you. The book warehouses all the cases, right, that are publicly filed with regards to multiracial claimants and their stories of discrimination. But the book itself is not just a sort of listing out of case after case after case. The book is organized in a way to try to amplify and illuminate the stories, the personal stories of the litigants themselves. Sort of, what is the multiracial experience of discrimination in these public spheres? And so I guess I tried to let you know it's not a dry read. And indeed, I thought it was only fair. I started off the book by disclosing my own multiracial status as a researcher as well. Right? So the very first line of the book is, I am the mixed race daughter of a mixed race mother, almost given away for her blackness. I don't think I'm ever going to have a better first line ever again. So I treasure that one. But in any case, so I go on to tell my story, sort of like how my own narrative instigates my interest in researching the cases, but not sort of foreclosing or having any predetermined assessment of what answers I would find by looking at the cases. But just that's what inspired me to look at these cases more closely. For those of you who are not students but instructors yourselves, the book also has an instructor's guide for use in the classroom with ideas about questions to ask and that sort of thing. But I think I have probably taken up enough time, and you might be biting at the bit to ask questions yourself. If not, of course, I'm always happy to share more of the stories in the book. But why don't I create some space here, Dave, for people to be able to ask questions? I could? Okay, so I will do that. Do you want to take a cue, or should I just? Oh, okay.
So I think I'm looking for a hand, so I don't have it right now. But so you can go ahead and let's go through it.
That pregnant pause in the room. Well, I'm happy to share another sort of aspect that I didn't get a chance to, right? Because I focused on employment discrimination. Another aspect of the book are the cases that are filed on behalf of multiracial victims, but not by the multiracial victims themselves. Right? This happens more often in housing cases. One of the main sort of stakeholders in these cases are white grandparents and some parents of multiracial grandchildren. What the stories are that get revealed are, grandparents loving their grandbabies, moving into some new housing complex, as they move into, downsizing, etc. And then having the grandchildren come to visit or to stay for some extended visit, and then having the landlords of their buildings find their tenancy problematic. Sometimes this happens because they see a photograph of the grandchildren. Sometimes it happens because they see the grandchildren wandering around the premises. And this is not one of these places where you can't bring kids, just in case you were be like, oh, well, maybe it's not for the race reason. Maybe it's because, they don't like children. No. Lots of other children are wandering around. It's when they see these brown babies that the landlords find this problematic. I mean, what's very interesting, too, about these cases is that, for many of the white grandparents, this might be their first encounter, right, with the way in which their grandchildren are adversely received and treated. And so it's sort of an interesting story of awakening on their part. I mean, the book is not sort of focused on that, but it's part of the journey. And so, I'll lay that out as well as another interesting aspect of what this means to be part of a multiracial family as well. Having to be, unfortunately, exposed to the negative aspects of how racialization operates, even when we want to protect our children and, are not viewing our children or our grandchildren in a racialized way, we still have to sort of confront the world's view of them.
Yeah, so this is going back a ways, but you were talking about how Title VII doesn't have language that enumerates, particular races or anything. I guess I'm curious if you think people of multiracial people ever feel less entitled to bring litigation because they somehow think they're not covered by Title VII or something like that.
That's interesting. I mean, because my intervention was in trying to assess, do judges misunderstand, right? Because the thesis was, oh, judges don't understand this. They misapply law. They dismiss the cases out of hand. That was what my main focus was. In order for me to sort of really empirically research that, I would need to be able to reach the cases before they even got there, right? So I'd have to talk either to lawyers or to hotline centers or in other ways try to survey the population. I will say anecdotally, right, and trying to be responsive, when I presented the research to multiracial community groups, they have not described that as part of what they perceive to be the problem. I mean, obviously that's not definitive, but sort of feeds my intuition that might not necessarily be driving what I see in the pattern of cases. Way in the back.
Hi, Tanya. So, first of all, I'm supposed to talk. I have a loud and obnoxious voice. So first of all, thank you very much, and it's really a thoughtful treatment. I guess I want to ask you to talk a little bit about it, not from a judicial decision-making point of view, but from, I suppose, a policy-making or coalition point of view. So, for example, just to bring up a real example, Dave Evans, who's been the admissions director here for a million years, he's admitted me, let's put it this way, when I admitted to Harvard College, that's all, he's been here, he's still on the job. But if you look at the number of black students at Harvard, he asked me, how many do you think have 4 black grandparents born in the United States? And the answer is, it's been a very, very rapidly declining percentage. And that says something. It's also true if you ask how many people come from working class backgrounds as opposed to professional class backgrounds. That's also been a steadily declining percentage. We just did a big survey of Harvard Law School graduates in which something like 80-something% come from families with professional backgrounds, and that more than a third of about 28% of the black students identify primarily as something other than, let's call it, black or African American. So the question is what to make of all of that, right? It's one thing to say people will use this as a wedge issue to try to undermine affirmative action. I think that's your critique of Justice Roberts, which strikes me as just right, and lots of other people. But the question is whether it's an issue, and whether or not it's something from a social justice point of view, from what we think about what it means about who is being served by affirmative action programs, what are the class implications of it. It might mean something, and it might also mean something about what it means for the community of black students here. So I wonder, as somebody who's thought a lot about this issue, how do you think about it from that point of view?
Well, I mean, I think what that question raises for me is that to say that multiracial discrimination when it happens in public spheres is not something novel and alien for a legal system to comprehend does not mean that the multiracial body isn't situated differently vis-a-vis lots of other aspects of and dynamics in the world, right? So that is to say, just as it's not the case that low-income Latinos for application to elite colleges are similarly situated, right, to high-income Latinos. We see a similar dynamic with, I'll use a more explosive term, those who are racially palatable, right? No, this idea of what's your socioeconomic status, what are your networks, what are you bringing here? Are you going to be one of these loudmouth kind of minorities, or are you going to be one of these more, you know how to behave yourself and not rock the boat kind of minorities? And are the proxies being drawn, right? Because how do you know who's going to be the loudmouth? You don't know. We never knew Justice Souter was going to rock the house, right? But he was real quiet about it. Then he gets on the Supreme Court and he's like taking care of business, right? So sometimes you can't do that. But what do we see? There's been some very interesting sort of ethnographies of admissions officers revealing the extent to which they're using these proxies for like what are people who, are a good fit for the institution. These are codes, right, for people who will like keep status quo, not challenge the way things have been done in the past, etc. So certainly the multiracial body is not always treated exactly the same way, just in the ways in which even if you take away the current concerns about multiraciality, or this idea of monoraciality, there's still cleavages there, right, that are not adequately attended to necessarily within an affirmative action program, that can and should be addressed. Okay. Another aspect of it, though, that I wanted to sort of raise up, because I found it really quite fascinating, when I was giving a talk about the book with litigators. And so I know you told me not to focus on law, but I think you will find this interesting. Professor Wilkins. Representatives from the NAACP Legal Defense Fund were saying to me, Tanya, I think sometimes people identify along with their multiraciality because that's their personal expression of themselves, but they're not necessarily sort of thinking through what some of the consequences will be with other of their needs. So for instance, in ongoing litigation regarding segregation in public school systems, right? Some schools, districts are still under court order, right? They're under court supervision to see whether they will stop barring minority students from being part of the student population. And part of the ways that this gets monitored is, it's crude, but this is what's done, counting happens. How many do you have who describe themselves as X or Y or Z. And then we can look at the numbers and see whether statistically there seems to be an inference that either there's too few compared to the population, so you must be excluding them, or it sort of reflects the population or significantly close enough that we think, okay, you're not getting in the way of students of color enrolling in your school district. Here's the interesting thing about multiraciality that folds in. Some of the school districts that are still under court order are becoming at risk of losing any court supervision, despite having a history of being very bad actors, because people who previously had identified as singularly as black have started within the school district identifying their children as multiracial. And the school district is saying, hey, it's like that. I don't know if any of you are Portlandia TV fans. I don't know, I really watch television or whatever. But in any case, there's an episode of Portlandia where it's a comedy show for those of you who don't know, where the workplace is concerned that they're not very diverse. And they're not able to recruit people to come to Portland, Oregon, and et cetera. So they decide to take the DNA ancestry case, the one, me and you, I forgot the names of these ancestry case tests, right? I need Professor Gates to, come in and explain it better, right? Okay, so they take these tests, and then the next day, the HR, the human resources person comes in during the lunch break and says, hooray, we have met our diversity goals, right? Just by taking the Ancestry.com case, because now everybody in the workplace is mixed. Right? So it's the strategic use, right, of multiraciality that comedy show is trying to highlight, but is somewhat resonates with what the NAACP Legal Defense Fund litigators are seeing, putting at risk in the work that's meant to protect children and give them integrated school settings and give them quality education. So there's lots of, fascinating both public policy and continuing issues that need to be addressed. My goal was a very sort of more modest one, right, to sort of try to at least as a first pass intervene in this, what I thought was a very problematic kind of presumption about the inadequacy of civil rights law. I mean, I also have another hat. I can critique civil rights law just as much as anybody else. I don't think it's a perfect animal by any means, but I don't think it is problematic for the reasons that are being asserted by these multiracial identity scholars.
When judges make their determinations, do they usually base what they determine to be the race of someone off of presentation, or do they examine genetics? And also, how does a passing discourse impact how judges make that determination?
Okay. It's all based on self-identity now, just like we have historical examples that I could give you of where judges were all like, well, what's the width of the nose and what's the texture of the hair? But that's our past. We're hoping not to reprise, right? And what we have now, just like in our census, is self-identity. You say you're X, we believe you're Y. We believe that. What is interesting, though, is an example of this is the court just taking it at face value and then trying to assess where's the because of race problem in the fact pattern, comes up with a Michigan case, a recent one, you may have perhaps read about it in the news, of a gentleman named Cleon Brown, a police officer in Michigan who is, as sociologists help me use the term, white presenting. Right? So he looks white, he believes he's white, his whole family, they've always thought they were white. Police force for 10 years at least, right? He then decides he wants to take the Ancestry.com test because he's long heard some family folklore that there's a Native American ancestry in the family. And he was like, he wants to explore this. Gets back the results. Lo and behold, there's no Native American ancestry detected in the test, but 18% sub-Saharan African. Okay. This doesn't bother Cleon, right? He thought, kind of like, wow, this is kind of fascinating. I would have never expected this. So he goes back to work, because as one does, right? You share your things that happen in your life in the workplace, because where do you spend most of your time besides home with your family? At work. So he tells his fellow police officers, look what happened when I took this test. As we say in Spanish, ¿para qué fue eso? Why did he go and do that? Right? Because then the harassment starts. He's been their co-police officer for the last 10 years. Doesn't matter. one little whiff of blackness, out come all the jokes. Out come the references to him as Kunta Kinte, a slave named from the Roots book and television programs. It's not just name calling though, because you might say, oh, Professor, come on, he needs to develop tough skin. It's just name calling. Well, no, the name calling is also accompanied by denial of access to public goods. Like what? Job training that could advance him in his position. Mm-hmm. Important meetings that are, again, important to advancing. Right? Police officers always taking the next test, trying to be lieutenants, etc. Right? And so when he's blocked from these things and eventually demoted and fired, he says, wait a minute. I've been a police officer for 10 years, no problems, and now I reveal my ancestry test, and now it happens? So he doesn't say he's black. Right? He says, I'm white, but I have these test results that have this blackness, and because of race is why I've been discriminated against. Okay? The case just recently settled out of court, and he was provided with some financial remuneration for his harm. So I described that case just to be able to describe to you the ways in which, it's truly not about like the court trying to fixate the, what are you? Where you people from? Kind of, where'd you grow up? There's all the gentle ways trying to get at, like, I'm really want to be in your business, knowing, who are you? Right? The courts are not there to be assessing your race, and actually kind of find it distasteful, right? So they'd rather just go based on what you say you are, and then look concretely at the dynamic, the context, right, is what matters, right? The racialization pattern is what matters if that's what's blocking you from being able to be treated just like a human being, right? Just like another coworker, just like a applicant for housing or trying to get admitted to some sort of public accommodation or restaurant, et cetera, right? These are all the spheres in which I look at how discrimination operates. Did I miss any hands?
Hi, so you talked a little about, like Title VII just refers to race, national origin, and so on. I'm curious if you talked about 42 U.S.C. 1981, which specifically talks about giving everyone the rights that white persons enjoy, how that plays into this analysis.
Well, you know what was fascinating? I wanted to be able to examine every context in which civil rights law is important, right? So that includes public accommodations. And what I found the most interesting is that was the one sphere where there were very few cases. Very few cases. Let's say there aren't few cases of public accommodations, but few cases of multiracial identified claimants saying that they've experienced some kind of barrier to access to a public accommodation under Section 1981 or otherwise. And what I sort of theorized from that paucity of cases is that perhaps it's because this is the one sphere in which your barrier to access is really just about your appearance, right? Meaning there's no knowledge about you when you try to get into the restaurant, when you're trying to shop, while, etc. They know nothing about that, so it's harder to say it's about your multiraciality because contrary to what the public media wants to assert, multiraciality doesn't look any one single way. When they sell us stuff, they try to, have one kind of picture of what that means. In fact, I just recently got this very odd call from the BBC because they were following up on a story of a police officer and an Amber Alert. A young person had been kidnapped, and they were putting out the notice to let the public know, please look out for this child. She's in danger. She's been kidnapped, etc. And the Amber Alert described her as mulatto. Yeah. And so the BBC wanted to know, Professor, what do you think about that? Isn't that, a derogatory term, et cetera? I said, well, yes, it's historically a derogatory term, et cetera. But it could very well be that the police officers, right, they're not trying to do harm here. They're trying to save a child's life, right? And that could be a police officer responding to the very rhetoric of his community. There's this phrase called mulatto pride, raising up multiracial identity, and the consumerist trend that we see by advertisers as tying a particular face to that mixed race identity. Right? And so it could very well be that this was the police force. You want to be as detailed as possible in description, before someone gets to see the photograph, right? All they're hearing, or some of you get those Amber Alerts on your telephone, right? Depending on how your phone system works. You're just getting language, you're just getting text. So you need the text to be as descriptive as possible. So that language of mulatto, yes, it's historically problematic, etc., but he could have very well been using it, picking up on this rhetoric of the exceptionality of multiraciality and as of having some sort of preordained look. Right?
Thank you. Thinking about other countries that tend to self-identify more than the U.S. as multiracial, thinking about like Brazil, for example, are there any lessons or learnings that you can draw from the experiences in those countries that could be useful for what's going on in the U.S.?
Indeed, indeed. In case it didn't reveal itself, the Hernandez surname is not just a mere surname, right? It comes with a Latina background. And the reason why I start off the book with my own personal story, which I've never done before. That was sort of a new experience for me. And I still have a little bit of trepidation, I have to admit, when I encounter a reading public, putting myself so out there. But in any case, the reason why I did that is because I wanted to sort of describe the ways in which an Afro-Latina who comes from a background in which racial mixture, mestizaje or mestizaje, right, is lifted up as this like celebratory cultural identifier, meaning we are better than North America because we acknowledge racial mixture and we celebrate it, right? We don't have black or white, we just have all of us mixed together. Or like they say in Venezuela, we are a café con leche, we're a coffee with milk, some of us more milk than others, kind of society, right? And the reason why I sort of brought in my prior research about Latin America into this book that's just about the United States is because I wanted to situate the ways in which these ideas that seem to be circulating in the U.S. as something new are not new themselves, right? Mestizaje pride, mestizaje pride, these are old tropes that have been that are circulated and never to the advantage of dismantling racial discrimination. Right? If anything, many Afro-Brazilians activists will let us know the ways in which they think that the mestizaje rhetoric has undermined their challenges to racial pathologies in their own countries. And so while the book itself doesn't bring in all the comparative stuff, it references it so that people will buy the first book, in which I deal with racial subordination in Latin America, and this very same trope of racial mixture. So in some respects, the multiracials and civil rights is sort of part 2 of the journey of looking at this from a global perspective.
So, on behalf of all of us, thank you so much. Let's have a round of applause for
Thank you very much.